All right, ladies and gentlemen, we're going to go ahead and jump right into chapter 8, where we talk about interrogations and confessions. This is kind of a long chapter. There's a lot to talk about. We got a lot of hot button um, topics and things that are relevant to today. And as a fact, I'm going to probably refer to a lot of things that happen in the movie When They See Us. I don't know if anyone has watched that movie yet, but I'll be referring to some of the things that happened in that movie, because that movie was all about interrogations and confessions, and how confessions, interrogations can be used, how they can be biased, how they can be undependable if not done the right way. So, as a basic introduction to chapter 8, this is chapter 8. Confessions are an effective method of criminal investigation and detection. An admission of responsibility and guilt is an important step towards a defendant's rehabilitation. It also helps law enforcement because no matter what we think about cops, there are bad people out there that do bad things to people, people that victimize people, people that murder them, people that steal from them. And it's always good. It's easier on law enforcement when someone comes forward or they feel like they found the right person and talk to that person just says, "Yep, it was me. I did it. I stabbed the person. I shot the person, or I stole their TV." So there's an interest in detecting crime, and it makes it way easier when law enforcement solves crimes by people saying, "I did it." Now, normally with good law enforcement, they also try to corroborate what this person is admitting to as well. So that's the problem in some situations. You can't just take a confession. You have to listen to the confession and then also go back to the evidence as a law enforcement officer to make sure that it matches up. So we're not, I don't think it's ever a good idea just to take a confession because a person walks in and they say, "I did it." Um, so you want to corroborate what they're saying they did as well, so that the confession can be depended upon to get a criminal conviction, and that we make sure that the right person is put behind bars. And we'll talk about that right person thing because a lot of times, if sometimes in law enforcement, we feel as people that they just want to make an arrest and close cases. There's a difference between closing the case and getting justice. I think what we really want our law enforcement officers and prosecutors to do is to seek justice, meaning we want the right person, the person that did it, to be punished for things, as opposed to the first person we can find to be a scapegoat, so we can now put it to bed. That's not right. It means that a person that actually victimizes people or that is a bad person can actually that person still out and they can do it again. So one risk of relying too heavily on interrogations is coerced or false confessions, as I said before, as I was just talking about. The poor and uneducated are likely to be particularly vulnerable to coercion and trickery. Not just poor and uneducated, poor, young, and uneducated. Confessions, in effect, result in guilt being determined at a pretrial stage rather than in a trial courtroom presided over by a judge and decided by a jury. The constitutional regulation of interrogations is designed to assure the confessions are the product of fair and regular procedures and are not the result of police coercion. There are three constitutional approaches to regulating confessions. The voluntariness test, based on the Due Process Clause of the Fifth Amendment and of the 14th Amendment, that's one. The Miranda rule that is required under the Fifth Amendment, and the protection accorded under the Sixth Amendment right to counsel. So we're going to talk about those approaches and certain tests that we apply. First, we're going to talk about due process. So, like I said before, due process, we use it a lot, of course, in criminal procedure, but what it means is essentially, has a person been given a fair shot to defend themselves? Is it fundamentally fair what's happening procedurally? So that's those are the questions we always ask, or that's what we're always thinking about when we say due process. Is it fair? Does the person have the ability to defend themselves? Do they have access to what they need to defend themselves? So the due process test asks whether a confession was voluntary or involuntary. In other words, Did the person give it at their own volition? In other words, they say, "Hey, I did this. I want to tell you what happened," or did they get tricked, coerced, or beat up into saying this is what happened? So, in other words, I'll say, "I'll tell you what I think you want to hear, so I can go home." That is not voluntary. That's actually involuntary. So, if I'm telling you something just to satisfy you, so you'll stop hitting me, or so that you'll let me go home because you're keeping me captive, that is not voluntary. So, we're going to talk about that. Um, so, to be admissible in evidence, a confession must have been made freely and voluntarily without compulsion or inducement. It must not be the product of physical or psychological coercion that overcomes the will of an individual to resist. The involuntary confessions are inadmissible in evidence. So we'll talk about that. So we'll talk about when they see us, and I don't think this is a spoiler alert. I think anyone that's read history knows what happened in the Central Park Five case, or what they call now. They now call them the exonerated five. But we know what happened, so it's not really a spoiler alert because we know what happened. They went to jail, they got out, they were later exonerated, and they were paid a settlement. But that story is now kind of the exemplary, or the example story that everyone's now going to use all through the criminal justice sector to talk about coerced confessions and I guess botched interrogations as well. In determining whether a confession is voluntary, courts apply a totality of the circumstances test. Once again, you hear totality of the circumstances, probably one of the most repeated phrases in criminal justice or in criminal procedure. So, relevant factors include the application of physical abuse or psychological coercion, the time, length, circumstances, and place of the interrogation, the age and education of the detainee, along with other considerations. So these are all things that we look at. So in the totality of the circumstances, this is all we're looking at. They have you in a freezing cold room with no shirt and nothing on. You're in there free. You're uncomfortable. They're purposely making you uncomfortable so that they can coerce you into giving them what they want, so they can give you comfort. That is not if you give a confession in that situation, that is not voluntary. So we're going to talk about that. So it's psychic. So it's not just physical where they're beating on you. Sometimes it's psychological. Uh, um, there's a psychological certain tricks they can use to get certain uh, I guess confessions from you, and that's not voluntary. So, at various times, courts have indicated that the due process test is intended to ensure reliable confessions, to eliminate offensive police methods, and to make certain that confessions are the result of fundamentally fair procedures, and to ensure that confessions are the product of a rational and free choice. The due process test is subject to various criticisms. The major criticism is that there is a lack of clear standards, and that as a result, the test fails to provide guidance to police and courts. I don't really believe in that. Yeah, in that criticism, because I think we know when something is voluntary and when you're trying to play tricks on a person, and certain tricks are allowed. There's a difference between a trick and a coercion, where you're trying to push someone physically, mentally, or mentally. So it may not lack clear standards where it's telling the cops what they can and can't do, but a reasonable person knows I can't put my hand, if I'm a cop, I can't punch um, a detainee in the face to get them to say what I want to say. So I don't think we have to put that in the rule book. It's amazing how, and I know I'm going to sound anti-cop here, but it's amazing how they pick and choose when they want direction, right? So you don't need specific direction on how to act when you're talking to a person, or when you're interviewing a person regarding a crime. If you're in law enforcement, don't put your hands on them, and when it's been a long time. As a human being, we all have our natural faculties. We have to use the bathroom. If a person's been in the room 4 hours, like, yeah, maybe he has to take a bathroom break. Or if being in the room as a law enforcement officer yourself, if the air's on, it's cold. So if you have the same uncomfortable, if you're uncomfortable just like that person is, then it kind of becomes, I guess, what they call psychological torture in that situation. So if you're not comfortable, why would they be comfortable? So it doesn't mean you have to lay out the red carpet for a person while you're interviewing them, but there's certain small things that officers can do to coerce confessions, and and they know what's wrong and right. So I don't think there necessarily have to be standards. Just when you're wrong and when you're right. Um, let's see. Uh, all right. The McNabb-Mallory rule. All right. Where was that? Okay. The McNabb-Mallory rule. The Supreme Court sought clearer standards regulating police interrogations. In McNabb v. United States, uh, and the Mallory v. United States. Well, I'm sorry, let me just back up. In McNabb v. United States in 1943 and Mallory v. United States in 1957, the court held that that federal law enforcement officers were required to bring criminal suspects immediately before a judge. Confessions obtained in violation of this rule were inadmissible in evidence. So really, that means as soon as they brought a person in before they can interrogate them, they had, and this on the federal side, they had to bring them before they had to bring them before a judge before interrogating them. If they didn't do that, it was automatically inadmissible in evidence. Escobedo v. Illinois. In the Escobedo case, and that's a 1964 case, the Supreme Court extended the Sixth Amendment right to counsel to interrogations by state as well as federal law enforcement officials. The defendant was to be informed of the right to silence and the right to an attorney prior to interrogation. Um, and let me explain what we're kind of doing and how these chapters go when it comes to law. So in law, either whether it's procedural law or substantive criminal law, we always learn law by starting from the beginning of case law and working through what it is today. So, in other words, the book now is trying to teach you. So I know everyone's like, "Well, it sounds like the right to an attorney." That's part of the Miranda rule. I'm kind of trying to take you through how the Miranda rule ultimately got to where it was. What are the cases that happened before Miranda rule that take us to where it is now? So that's what I'm trying to do. So that's how the textbook and that's how all law books, if you ever go to law school, that's how they work. You learn a body of law, and you kind of stack everything, and at the end you have the masterpiece of what this body of law is saying about this particular subject. So that's what we're doing now. So the right against self incrimination. So we kind of so in the Escobedo case. So in the McNabb Mallory rule, we talk about how they have to go in front of a judge. At this point, they had to go in front of a judge, and this is on the federal side before they could be interrogated. Um, All right, and then we move on to Escobedo v. Illinois, where they say, well, they need to know that you have to let them know they have a right to an attorney, or they have a right to an attorney. Now we're going to talk about the right against self-incrimination, and that's the right to remain silent. So, the self-incrimination clause of the Fifth Amendment provides that no person shall be compelled in any criminal case to be a witness against himself. In other words, I don't have to tell you anything. I don't have to tell you that I did it, even if I did do it. This right was extended to the states in Malloy v. Hogan in 1964. The right against self-incrimination reflects the fact that the United States has an adversarial system in which the state has the burden of proving an individual's guilt beyond a reasonable doubt, and in which the defendant is not required to take the stand or to offer evidence at trial. So, as a defendant, I have the right to sit there and hush, even at my own trial. All the burden is 100% on the state. Now, here and there, if I wanna say something to defend myself, I can. But as a matter of fact, it can't even be held against me if I don't say anything. So a lot of times, in jury, when we're questioning jurors about, trying to determine doing voir dire, and we'll get to that later on what that is. But when we're trying to panel a jury and we ask them questions, we sometimes if I have a client that doesn't intend on testifying or even putting on a defense at all, I have to ask the jury. I have to make sure the jury knows that my client doesn't intend on testifying, and we don't intend on putting any evidence, and that they understand that they can't hold that against my client. And they have to understand that the burden is only on the state. So with the burden only being on the state, that means I also have a right not to help them in their prosecution of me. I don't have to give them any statements. I can remain silent, and it's up to them to get the evidence. I don't have to assist them at all. So that's essentially what the right to remain silent or the right against self-incrimination means. Um, the right against self-incrimination extends only to testimonial evidence that is incriminating. Testimonial evidence communicates facts, thoughts, and ideas, and is incriminating because it may lead to a criminal charge. So we're not talking about telling them what your name is or something like that. This is at the pre-trial phase. So when you get booked, they bring you in, they have you fill out just biographical information about who you are. That's not necessarily testimonial. Testimonial is when it's something that goes to the facts of the case. So I read again: testimonial evidence communicates facts, thoughts, and ideas, and is incriminating because it's only incriminating when it may lead to a criminal charge. So now that we've talked about the right to counsel, the right to remain silent, let's now go. And we talked about the right to be taken in front of a judge or being taken in front of a judge in the Mallory in the let me see in the McNabb Mallory rule. Now we're going to talk about how these things kind of all merge together when we talk about Miranda v. Arizona. So anytime we talk about someone being Mirandized, that's kind of a twist on the case name Miranda. So that means the defendant's name, his last name was Miranda. Of course, he was convicted of a crime. He appealed because he said, "Hey, I didn't know my rights. I didn't do this, yada yada yada." And the Supreme Court was like, "You're right." So at this point, this is the new rule. So Miranda v. Arizona, that's the original case, provides that statements of an individual subjected to custodial interrogation by the police may not be introduced into evidence absent procedural safeguards protecting an individual's Fifth Amendment rights. That means it doesn't come into evidence unless safeguards, or at least you let that person know that they have Fifth Amendment rights, and that a person can't be in a position to protect their rights unless they know they have them and are entitled to them. So they must let them know that, hey, you have a Fifth Amendment right to hush and not say anything. If you need an attorney, you have that right as well. But in other words, they have to be informed of their rights, as a safeguard. If this isn't done before an interrogation is done, or questions are given, or a statement is taken, then Miranda rights at that point, it's possible that your rights have been violated. Miranda requires that the police warn individuals of their right to remain silent, that anything they say may be used against them, and that they have the right to an attorney appointed or retained. Um, in Dickinson v. United States, and this is 2000 case, the Supreme Court ruled that Miranda was a constitutional decision, and that the Miranda warnings were required by the Fifth Amendment to protect a defendant's right against self-incrimination. The federal and state law enforcement agents were required, as a matter of law, to provide criminal suspects the Miranda warnings. Now, when is Miranda required? Because what I always get from people, everyone watches Law and Order, you watch TV. Um, what happens is, you watch TV and you see, as soon as people are arrested, they say you're under arrest. You have a right to remain silent and stuff like that. Miranda only applies, and we're going to go further into it, to custodial interrogations. So I get tired of clients coming in and saying, "Hey, but when they arrested me, they didn't read my Miranda. They didn't read me my Miranda rights. They didn't have to. Did they question you? No, they didn't question me. Well, they didn't have to read you the Miranda warnings. The Miranda warnings apply to interrogations and to interrogations. So what that means, if the cops have now put you in the situation where you're not free to go, meaning you're in some type of custody, either de facto custody or known and express custody. And in that situation, they're now going to ask you questions, and these are questions that are usually outside of the biographical, who are you, what's your name type questions. Those what happened type questions. That serves as an interrogation. Now, the cops arresting you or taking you into custody and having you, fingerprinted and booked. That's not an interrogation. So we'll talk about what all that stuff is. But It only applies to custodial, meaning you're in custody, and while you're in custody, you're being interrogated. So custodial interrogation. The Miranda warnings are triggered by placing an individual in custody and subjecting the individual to interrogation. So custody plus interrogation equals the triggering of the Miranda warning or the Miranda rights. That's what they should be read to you. The Miranda decision defines custodial interrogation as questioning initiated by law enforcement officers after a person has been taken into custody or otherwise deprived of his or her freedom of action in any significant way. That means it may not necessarily be in a police station. It could be on the side of the road and you're surrounded by cops and you're in a situation where it's like, yo, I can't take off and run, or I can't walk away without being roughed up, or, they're expecting me to stay here. And sometimes it even asking the question, hey, am I free to leave? If they say no, you're in custody. So if you're in the custodial situation and they now plan on asking you questions, in that situation, they have to give you the Miranda warning in order for what you say to be admissible. Um, Let me see. Okay, in determining whether an individual who has not been subjected to custodial arrest is subjected to custodial interrogation, courts ask whether, based on the totality of the circumstances, there it goes again, um, a reasonable person would believe that he or she was being subjected to a degree of custody consistent with being subjected to custodial arrest. The public safety exception. In New York v. Quarles, the Supreme Court recognized a public safety exception to the Miranda case. This exception permits the police to ask questions reasonably prompted by a reasonable concern with public safety without first advising a suspect of his or her Miranda rights. So that's one of the only exceptions. Miranda warnings. The three-part Miranda warnings inform suspects of their rights and consequences of waiving these rights. So it's not just what the rights are, but what the consequences are if you waive them. These warnings require the police to inform individuals of the right to remain silent, that anything they say may be used against them, and of the right of an attorney retained to have an attorney retained or appointed. The Miranda judgment specifies that these rights must be recited in clear, unequivocal terms, and that the suspect must be clearly informed of his or her rights. So these days, what they do, they usually have forms and they read the rights out to you and have you sign it. So the best way to show that someone waived their rights from law enforcement officers to have a form and show that they signed and dated it. So in other words, I waived my right. A lot of times they even give the time, and we'll talk about why the time that the waiver is given is so important in a minute. Okay, invoking the Miranda rights. Following the Miranda rights, following the reading of the Miranda rights, the defendant has the opportunity to assert his or her right to a lawyer or right to silence or to waive these rights. The Supreme Court held that an individual intending to articulate his desire to have counsel present must express this sufficiently clearly that a reasonable police officer in the circumstances would understand the statement to be a request for an attorney. So in other words, I want an attorney. That's it. That's unequivocal. So it must be said either verbally. If you can't talk, write it out, or sign language in whatever language you speak. You have to say it or write it out. In other words, it has to be known unequivocally that you want an attorney present. And once you say that in whatever form of broken English you may use, I know there was a case recently where a dude said, "I need a lawyer, dog," and a court actually held that wasn't good enough. But I beg to differ. If for cops in the room and they're trying to question the person, he says, "Yo, dog, yo, bro, you know how we talk in broken English. We don't talk perfectly. We talk colloquially." He said, "Yo, bro, I want an attorney in here." That's unequivocal. We know that man saying that he doesn't want to talk unless he has an attorney. So this is the same level of clarity required for invoking the right of silence. So if you don't want to talk, you got to say something. I don't want to talk, or not talk. That sometimes that can be not talking is not talking. But it's definitely best if you let them know you don't intend on giving a statement. So waiver of these rights. So of course these rights can be waived. So a person can go in and say, you know what, they told me I had a right to remain silent. Any statement I use may be used against me. And I know that. Thank you for telling me that, but I'm willing to waive that right. I do want to speak. I want to talk. so that right can be waived. Now, the Supreme Court stressed in the Miranda case that the government must meet a heavy burden in demonstrating that a suspect voluntarily, knowingly, and intelligently waived his or her rights. According to the Miranda decision, a waiver requires an express statement that may not be presumed from the fact that the accused is silent following a warning. So in other words, your silence from the cop standpoint, your silence by itself doesn't mean you waive. They have to have something that says, I waive. So in other words, so you have to tell them, and that's why now these days a lot of times they have forms. So of course, there's no better way. Either you're videotaping the person and you see them saying I waive my right, or there's a form that a person signs, dates, and it usually specifies the time that the waiver is given as well, uh, to let them know unequivocally that I waive my rights and I'm cool with talking to you guys. In determining whether confession was voluntary, a court will examine the totality of the circumstances. The primary focus is on the interrogation techniques employed by the police. The likely impact of these techniques will be evaluated in light of age, education, background, and other characteristics of the accused. The conditions of the interrogation and the length of the interrogation and of the detention prior to the reading of the Miranda rights. So that's why time is so important. So when you look at when they see us, when you look at when they see us, um, you have these guys that are range between the ages of 14 and 16 years old. Now me, I'm 38, so that was a long time ago. But I was an entirely different person when I was between the ages of 14 and 16. I couldn't imagine now being in police custody and being questioned. That would be that would be amazingly terrifying to me, to be surrounded by grown men who are using force, and even if you're not necessarily using force, banging my head against the desk or punching me in the face, just talking loudly to me in a situation where I'm accused of a heinous crime is super scary. There's nothing about that situation that made it voluntary. Anything those guys said in that situation, given their age, nothing about that was involved. The fact that they even tried to use that statement in and of itself means that the attorneys involved should lose everything. They should lose their bar light. And this is me as an attorney. But the prosecutors that use that information should be their bar licenses should be thrown away forever. And they should be like Linda Fahrenstein. We need to ruin her life. And that's just me. Now it's me speaking. This is my opinion. I'm your teacher, so I'm entitled to give it. But yeah, she needs to lose all that money from them books, everything. Just the fact that you have young people being interrogated by grown men, nothing about that is voluntary. Even if they want to give a statement, say, yeah, I want to give a statement, just based upon that fact, you have these young people there with no parents in this crazy situation. There's nothing about that is okay or voluntary. So it even they say, oh, the cops were nice, they gave them cookies. No, it's not. Nothing about that is voluntary. So the police officer may not. Let me see. Okay, so yeah, the impact of these techniques will be evaluated based upon age, as we've been talking about, and when they see us, education, background, sometimes the language barriers, and we deal with that when we deal with Hispanic or Spanish speaking citizens or people from other countries that come in as a language barrier. They're in a situation. Imagine being in a room where there are people talking to you, and you're trying to figure out what they're saying, and you can only figure it out via context. Like, well, that face he's making makes me think he's mad. But other than that, I don't know what this guy is saying. He's putting his paper in front of me. I don't know the context of what he's saying. Of course, in that situation, that's not that's one of the things that the totality of circumstances considers. Um, let's see. Other characteristics, also the conditions of the interrogation. In other words, was there physical force used? You had me in some type of deep, dark dungeon with drippy water and cold. All that stuff matters, especially if I'm 14-year-old. You got me in a dark room in a locker room where I feel like, yeah, somebody gonna jump out, beat me up, something behind me. Am I gonna get roughed up? Um, The length of the interrogation. So if you've been somewhere 5 or 6 hours, that's too long. Like, now if now if you got me waiting in the room for you to come in and you're making it uncomfortable, what you're doing is you're gonna trying to become my savior of the moment. So in other words, the room is cold, I'm shivering, you see I'm shivering, and you keep me in there for 4 or 5 hours, then you come in and it's almost like you've promised me, oh, we get you out of here and get you a blanket if you just tell us what we want. Or yeah, we'll get you a blanket in a minute. I'm more than likely in that situation going to say anything, and it's not going to necessarily be accurate, but I'm going to tell you what you want to hear so you can give me that blanket, get me out of this cold room. That is coercion. That is not voluntary. So let me see. So yeah, length of interrogation, and whatever detention prior to the reading of Miranda rights. So how long have you even been detained before they even read your Miranda rights? That's why I said the time is important. So some of these forms they put the time on there so that when you waive, you say when you waive. So they know, oh, he'd only been here 20 minutes, and we gave him Miranda rights, and he waived at this time. He got booked, or we brought him in at this time. So that's kind of how the law enforcement covers their rear end. A police officer may not automatically conclude that an individual knowingly and intelligently waived his or her rights. In determining whether a waiver is knowing and intelligent, a court will consider the totality of the circumstances on a case-by-case basis. Courts also will examine a defendant's emotional stability, ability to think clearly during the interrogation, general intelligence, and prior experience with the criminal justice system. In considering whether a juvenile has waived his or her rights, a court inquires into the juvenile's age, experience, education, background, and intelligence, and into whether he or she has the capacity to understand the warnings given him or her, the nature of his or her Fifth Amendment rights, and the consequences of waiving those rights. So, in other words, this person old enough, or do they understand? Do they have a general understanding of what's going on right now? They're being questioned, and what they say can be used against them. Do they know that? The safest thing to do, and of course, kids below a certain age, that it's required that there be parental consent in certain jurisdictions. But that just makes sense to me. Why would you? And I know we're going back to 1989 in New York and Manhattan with Central Park 5, but why would you ever think it was a good idea to have someone that young in a room and question them without their parents? And as a matter of fact, I think in that situation, a kid's cry out for his mama is the same as a cry out for an attorney. That means they want someone there. So get them someone there before you continue to question them. Everything about that was wrong. The fact that people are even arguing the counter and saying it was confessions. I'm like, yeah, you're an idiot. And that's not me being super liberal. That's it is what it is. Why? Like, I can only imagine myself as a 38-year-old questioning a young person about anything, having that conversation without their parent there, or gaining their consent. You talk about people that can't even consent to doing normal things, can't even smoke a cigarette. Can why would you question that person and put that person in that situation and think it would ever be cool to accept any statement they give without their parent or guardian knowing? There's nothing that's cool about that situation, and it's terrible. Um, a waiver may be express, a direct affirmative action, or implied from a course of conduct by the defendant indicating that he or she is consented to a waiver, meaning I'm cool with talking, I'm going to talk to y'all. In most jurisdictions now, especially in North Carolina, they have, like I said, they have forms. So they say, hey, whoa, before you start talking, go ahead and sign this, then we'll talk to you. Because the police officers want to cover themselves. So waiver, what they call waiver, question first and warn later. Of course, that's out of order. It's supposed to be warn first and then question. The Supreme Court held that the issue when a police officer um, questions first and warns later is whether it would be reasonable to find that in these circumstances the warnings could function effectively to advise the suspect that he or she had a real choice about giving an admissible statement. So question first, warn later, this is wrong. The way Miranda wants it to be is you give them their Miranda warnings, let them know what's going on, and then you question. Anything outside of that is uncivilized, stupid, and it's inadmissible. Waiver following invocation of Miranda rights. So you can actually invoke your rights and then waive them later, but as long as you let that be expressed. Also, we're going to talk about the fact that you can actually start talking or waive those rights and then withdraw that waiver. So you can withdraw that consent at any time as well. The Supreme Court has held that the admissibility of statements obtained after a person in custody had decided to remain silent depends on whether his or her right to silence was scrupulously honored. In other words, was it actually honored? So if a person says, "Yeah, now I don't want to talk. I'm not gonna waive my rights. I want to wait for an attorney," then they sit there. Did the cops really honor that person's right to remain silent, or did they come back in 5 minutes later? Come on, man, say what we need. We're not gonna get your lawyer. Let's say what we need. So in that situation, we're always asking whether or not they were actually honoring that right that person invoked. An individual who invokes his or her right to an attorney may waive this right by initiating contact with the police. So if I say I'm waiting on an attorney, I want you to get me an attorney. I'm sitting there in the room and I say, "Nah, I'm good. I'll just talk." In that situation, that constitutes a waiver. Now we've talked about the custodial interrogation, waiving these rights. What is an interrogation? And this is going to be big because every statement a person gives to police while in police custody doesn't necessarily constitute an interrogation. So remember that. So if you see something or a situation where a person is in police custody, they're in a jailhouse, just because they give a statement or say something while they're in custody does not necessarily make it an interrogation. So sometimes in answering questions, you may get a essay, or you may get some type of a multiple choice question, hypothetical. You have to ask yourself not only, so of course, are they in custody? So remember the Miranda warnings apply to custodial interrogation, meaning one is the person in custody, but never forget to ask that second question. It's two-pronged. Is the person actually being interrogated? There's a difference. So in Rhode Island v. Ennis, the Supreme Court defined interrogation. The court explained that interrogation entails express questioning or the functional equivalent of direct questioning. Express questions are questions directed to a suspect by the police. The functional equivalents of direct questions are words or actions on the part of police other than those normally attended to arrest and custody, and that the police should know are reasonably likely to elicit incriminating response. Another way to really explain what interrogation is the police must be holding themselves out to be the police. So they must be acting under color of state law. In other words, I'm the cops. I'm asking you a question. So that doesn't prohibit them from using undercovers. Like, people jailhouse snitch all the time. They talk to other people. They talk to people in the jail. They talk to a person that's their cellmate, and they give up all the beans. What's to keep that cellmate from now turning state's evidence and going to say, "Hey, my cellmate just admitted to killing those people." So the same thing applies. What's the difference in a cop being undercover and dressing as a person that's in jail and getting this information? So an interrogation is just that. A cop who's holding themselves out to be, the police holding themselves out to be the police, um, asking direct questions. So, like I said, the court explained that interrogation entails express questioning, or the functional equivalent of direct questioning. Express questions are questions directed to a suspect by the police. So, it's in other words, I'm letting you know I'm the police. You're here, and I'm questioning you about something. I want to know what happened. So, if it's a situation where a person's not held out, and there's no, you don't, know whether or not a person is the police, and they start asking questions, that's different. So if and let me give an example. So if I'm talking to my cellmate, as I said before, I don't know who that person is sharing the cell, but if I'm just volunteering information to that person, I don't know who that person is. That person could be anybody. They didn't have a police uniform on. They didn't introduce themselves as such. Then that's not an interrogation. So they can come in, "Hey, what you in here for, dog?" that what you in here for question. Actually, in real life, what I've heard from jail might get you beat up. And don't ask person. None of you guys are going to jail. I'm not either, and I'm not either. But they say that is the question that'll get you. You're supposed to punch a person on sight for asking why you in there. But when sometimes a cellmate may ask that question, and once you start talking about it, and you say, "Oh yeah, I'm in here for that robbery the other day. Yeah, I robbed that dude." Now you've essentially you snitched on yourself. You told someone that could go tell on you, so you're not protected by being stupid. So the Sixth Amendment right to counsel and police interrogations. The Sixth Amendment is applicable to both federal and state government agents at or after the time that judicial proceedings have been initiated against the accused, whether by way of formal charge, preliminary hearing, indictment, information, or arraignment. The accused must also have requested or arranged for legal representation. The Sixth Amendment prohibits the government from intentionally eliciting information from the accused. This prohibits interrogations and prohibits creating a situation likely to induce a defendant to make incriminating statements concerning a pending charge without the assistance of counsel. The suspect must voluntarily, knowingly, and intelligently relinquish his or her right to an attorney. So it's not just the right to remain silent, but it's also the right to an attorney. So all that applies. So it must that waive. If you're going to waive that right, you must do so expressly and unequivocally. And if you're going to invoke that right, you need to ask them. Say, "Hey, I want an attorney." At that point, you've now invoked your Miranda right. You invoked your Miranda right. So I believe I've covered everything in chapter 8. As I said before, now it was kind of a long. It is a long chapter. Um, I tried to breeze through it as fast as I could, but I don't want to. I don't want to. I don't want to compromise quality of learning and quality of instruction for speed. So my job is to make sure you learn the information. So, and your job is to make sure you learn the information as well. So, like I said before, my lectures are nothing more than a supplement to the actual book. So it's your job to get in this book and read your textbook and read through review questions and prepare for class. Prepare before looking at the lecture. So this lecture is nothing more than the sermon. You guys go to church. You need to read your word, and the preacher just preaches something from the word. But you need to be your own person and know the stuff yourself before just coming in depending on me to spoon feed you everything. So there's chapter 8. Of course, the remainder of the week, of course, this will be posted on Tuesday. There'll be another discussion board on the 17th of July. Um, and there'll also be we'll also review the writing assignment um, on the 17th. And so we'll talk about that. So there'll be another there'll actually be another posting on the 17th, a discussion board, and another lecture just about the writing assignment. We'll probably go back over legal writing again, talk about that once again. And then Thursday, the 18th, the midterm will be posted. I also have a midterm review lecture up, so it may be good to look at that lecture before you even go into the midterm exam. So I'll talk about the specifics of the exam. We'll go from there. But as for now, you guys be good. We'll see you later on. Bye bye.